Welcome back for the final session. So, this is our panel on the path forward, and I'm very happy to introduce the panelists. First, on my right, Carrie Cordero. Carrie's at Georgetown, where she has launched and, since the launch, directed the National Security Studies program, which I believe includes an LLM.
Right, an LLM degree in national security law.
How much I wish that had been there when I was in school. That's really cool. And also adjunct professor teaching there. Carrie's background includes substantial experience at the Justice Department, among other things, counsel to the Assistant Attorney General for the National Security Division, and extensive practice in connection with the FISA court. She's also worked in a legal capacity at ODNI. To my left, Julian Sanchez. Julian is a fellow at the Cato Institute. He's written for innumerable publications, among other things, writing for The Economist, for Reason, for The Nation, serving as the Washington editor for Ars Technica, which is a really nifty website, and also one of the founding editors and authors at Just Security, the blog we've mentioned a few times. So we have wonderful people to weigh in on questions of reform. And as a way to ease our way into the topic, I'd like to spend time before we get into the details of particular reform proposals in different areas, set the stage by walking through the chronology of events over the past year, or almost a year. Gosh, it's been that long already. And kind of keep us on the same page. There are a number of different reform initiatives that are out there, and I think this context will be very helpful. So I'll ask Carrie to launch us with that background.
Okay, all right, thank you, and thanks for having me here. This has been a terrific day and a half. So we thought it might be useful, coming off of the conversations from the past day and a half, laying out sort of all the substantive issues that have been raised, to just briefly start with a little bit of a chronology of then how the reform proposals and that process has evolved over the last 9 months or so. And I think they can sort of be broken up into sort of 3-month intervals in terms of how the reform ideas and actual proposals, some of them actually in text and in the form of legislative proposals, have evolved. So starting with the unauthorized disclosures in June 2013, and just to sort of give my perspective on that a little bit, I think part of what we saw in terms of the immediate reaction from the intelligence community was somewhat of going into a defensive crouch. And I think part of that is reflected in the fact that the community itself was frankly shell-shocked by the disclosures themselves, and there was a from my perspective at least, slow reaction from the political leadership to launch a vigorous explanation of the underlying activities to tamp down some of the public concern that was part of the initial outcry and reaction to the media release. So the summer sort of evolved in that way, and there really from the government was sort of this reactive position to the increasing disclosures that came out then as reported through the media. As we approached into fall, I think the fall became all about Congress and what was Congress going to do as a result of the prior several months of public and media discussion and debate. And so what we saw in the fall was, first of all, there were a lot of different legislative proposals from various members of Congress, both in the Senate and the House. But there are sort of 2 main legislative proposals that are worth highlighting. One was a bill that was introduced by the Senate Judiciary Committee. The other was a bill introduced by the Senate Select Committee on Intelligence. And both of those bills tried to address some of the issues raised by the disclosures, and I would suggest that they focused on 4 main themes. And those are, first, with respect to the bulk telephone metadata collection program, or the 215 program that we've been discussing over the last day and a half, whether to end it and whether to legislatively end that particular program or bulk collection more broadly, or whether to modify the existing collection program. And so the Judiciary Committee bill fell on the side of ending the program. The Intelligence Community bill fell on the side of modifying the existing program. Second, adversarial process, whether or not to add some type of adversarial process to the FISA court activities. And again, this came in the form, there's sort of two, there's more than this, but I'll summarize it in terms of two varying proposals. One that would offer an institutional office of special advocate. The other sort of being an enabling procedure whereby the court could call upon an amicus to provide advice in special circumstances. And again, the Judiciary bill came on, and some of the other proposals that came out from members who sit on Judiciary focused on this institutional office. The Intelligence bill focused more on the enabling amicus. The third and fourth sort of themes that I would say emerge from those two bills are whether or not to limit in some way content collection, focusing on what we've discussed as the 702 program, or the amendments to FISA by the FISA Amendments Act of 2008, which focuses on content collection targeting non-U.S. persons reasonably believed to be overseas. And then the fourth theme would be transparency. And there have been various bills, and each of these two bills contain provisions focusing on sort of what can be more public reporting, whether or not more decisions or opinions of the FISA court can be declassified, and items like that. So in the fall, there were a lot of hearings, both in the House and the Senate. Julian and I participated in some of them, and on top of that, the other sort of aspect I would draw out from the fall is that the federal government had sequestration going on at the same time. And that really did present an overlay into the whole legislative debate, and I would suggest from the perspective of the executive branch, presented a lot of challenges regarding how much attention and time the executive branch personnel could be trying to solve the issues that were raised, because they were dealing with a separate budget crisis, in which case many of the agencies had their civilian workforces furloughed. And so I think that played into the activities of the fall. So fast forward now to the winter. So fall saw a lot of congressional action. Then in the winter, we had a few different developments that played into the evolution of the reform proposals. In the December, the Surveillance Review Group, which was the presidentially appointed outside panel of 5 former intelligence community professionals or legal scholars that was tasked with reviewing surveillance activities. The Surveillance Review Group's report was issued in December, and that focused it on a range of issues that perhaps we'll talk about it a little bit in more detail as we go through for the next, for our session. But they made a lot of proposals, over 40 different proposals, some of which then, bringing us to sort of the next milestone, the president either adopted or did not adopt when he made his speech on January 17th of 2014 and issued at the same time a PPD 28, Presidential Policy Directive 28, which contained a number of additional proposals to implement reforms on the way signals intelligence is collected and analyzed and handled by the NSA. The next thing that happened, interestingly, was about a week later, the PCLOB, the Privacy Civil Liberties Oversight Board, issued its report. So during the fall, the review group and the PCLOB both were conducting their investigations and reviews. And then the PCLOB report came out after the president's speech, which sort of was its own interesting political dynamic, because some of the recommendations made in the PCLOB were sort of overtaken by the changes that the president had already decided on by January 17th. And I think as we go through also, we'll come back and talk more about what proposals he actually implemented in his speech and through the accompanying policy document. And then we fast forward from there. So then he sort of, the president directed that within 90 days, the administration officials and the intelligence community professionals need to come back to him with proposals about what to do about some of the reform ideas, in particular the telephone metadata program. And he directed that they come back with proposals by the end of March. And so we just saw a recent flurry of activity where at the end of March, on March 25th, the House Intelligence Committee put forth its own intelligence proposal bill, which picks up on some of the themes that were in the earlier legislative proposals, but approaches things in a little bit different way. And then 2 days later, the White House announced its conceptual framework for the way forward, in particular on the telephone metadata program. And so I think that sort of brings us up to where we are today, and as we go through, we can talk more about sort of what the meat was in each of those proposals.
Terrific. Well, one thing I want to add is to get on the table right now that there is a little bit of a forcing function in the sunset clause. Section 215, which as we discussed yesterday is the current statutory foundation for the bulk metadata program. There are all these proposals now in place for how that will be changed. It's important to bear in mind that something's going to have to happen because it's going to have to be affirmatively renewed. Even to have the status quo continue with no change, you'd have to have something passed by Congress. Now, the sunset for the current authority expires, I don't know what month, but it's in 2015. It's, I believe, after the next election cycle. So that's another interesting political wrinkle. There's a question of what comes next if you don't act during the current Congress. Now, against the backdrop of that overview, which highlights for us that there are some existing presidential actions that already have reformed things in certain ways, there are proposals from multiple semi or outside bodies, and then there are legislative proposals all in the mix contending with one another. We will come back to a lot of the details in a minute. As a further bit of foundation, I think it would be wise for us to stop and ask, what is it that this larger complex process of reevaluation and possible reform is meant to achieve? What possible goals are to be served here? And Julian, I thought I'd ask you that question. What are the aims of this larger system of review? What should they be, rather?
Well, I mean, from a 30,000-foot view, one central one is to provide public clarity about what the law is. I think even people who substantively, support something like the 215 bulk collection program were somewhat dismayed to see that they had, as Nathan Seals put it, hidden an elephant in a mouse hole. That even if you think this is an authority they ought to have, that when you're implicating records of millions of ordinary people, and a sort of natural reading of the statute would not make it clear to you that what you've authorized is bulk collection. That's not appropriate. That at a very abstract level, an informed person should be able to read the statute and have a general understanding of what the scale of activity it authorizes is. I also think that it's important to craft reforms here that address underlying authorities rather than sort of creating spot solutions to particular sort of controversial programs. Because I think what we're seeing with a number of proposals, certainly the president's here and to a lesser extent the HPSI one, is a sense that what needs to be addressed here is this one controversial program involving phone records, and so what we need is a solution that involves some kind of limitation on the collection of phone records. To my mind, the underlying issue here is the court has interpreted relevance, which is language that cuts across a number of statutes, in such a broad way that it could easily be used to authorize very large-scale collection of a very large number of types of records. They have some argument to the effect of, well, communication records are sort of special, and so this argument is especially applicable to these types of records, but a lot of kinds of records can show potential connections or not retained indefinitely and might be useful in the future, and so would be nice to have, so you can be sure that if you later develop suspicion about a particular party, you can go back through them. So I would hope that an effective reform would address not one program people are upset about, but an underlying authority, and to basically determine whether that legal power is cabined appropriately, not whether the current specific use of it is something we're comfortable with. And that's to say, more generally, that is something I think a problem we see is that we have reforms that are crafted with particular current activities in mind, and so you have an interface between restrictions in the statute and rules that are to some extent discretionary, on the assumption somehow that the discretionary part is going to be static. We saw this to some extent in the case of national security letters. Those were expanded pretty drastically in the Patriot Act, with the restriction that they be used in authorized investigations. This was understood to mean full predicated investigations, and then the Attorney General guidelines changed somewhat to allow the use of NSLs in preliminary investigations. Very quickly, you see most of them being used in preliminary investigations. So I think reform should sort of not assume stability in discretionary activities, sort of assume that what is discretionary may change. And I also think there should be an aim to create uniformity across authorities. There's an enormous amount of overlap here. A lot of information you can get under 215, you can also get with a pen trap order, you can also get via physical search, you can also get via national security letter or grand jury subpoena. And so, certainly one concern I have is that if you suddenly say, well, we're going to raise the bar very high for acquisition of data under something like 215, which requires judicial approval, and then do nothing to change the underlying standard for, let's say, national security letters, which is clear the FBI prefers to use anyway when they can, because you don't have to go, make an application to the FISC. You just sort of get a special agent in charge to sign off on them. You're essentially pushing them toward the less overseen authority, which seems like a sort of huge mistake. So I think it's important to look at the system as a whole. So one difference between, say, USA Freedom and some of the other proposals, including HPSI, is that it creates a standard that it attaches to relevance wherever relevance appears. So it's not, you can get records that are relevant to investigation and pertain to an agent of a foreign power or the direct contact or the activities of a subject of an investigation, and establishes that across pen register, NSL, and 215. Otherwise, you end up again with a situation where you've essentially just told them, if you want less restrictions, go use the other authority.
I think that balloon squeezing effect that you've identified is a really important principle to bear in mind, that it's isolating the different authorities and treating them under the microscope over here and ignoring the rest misses the systematic interplay or potential systematic interplay amongst them. Carrie, what about you? What are some first principles or larger goals that should be guiding this reevaluation process we're living through?
Well, I think one point that's important to bring out is that I think there is a real question with respect to the reform proposals in terms of what goals are we trying to achieve through these proposals. And to some extent, there needs to be a recognition that, number one, in none of the reviews that have taken place to date have there been any revelations of intentional abuses or wrongdoing by NSA or the intelligence community. So there have been, there is legitimately sort of concern about the fact that the public did not perhaps understand the way certain laws were being implemented. There's legitimate criticism with respect to the existence and sort of whether or not compliance matters were handled appropriately. But there have been no allegations from the review group, from the P Club, or that have been revealed through the declassified opinions of the FISA court of intentional abuse. And so with that backdrop, the question that becomes, okay, so then what problem are we trying to fix? And do the legislative proposals or proposals being made by the administration actually fix existing problems? Some of the proposals that have been put forth are really ideas that are not new. Members of Congress who have had longtime criticisms of intelligence community operations, some of the positions from the advocacy organizations that are being expressed with respect to concern about surveillance activities. These are not really new criticisms. They are simply now concerns that have a platform to be addressed, and so this is sort of the moment for those proposals to either take place or not. So I think one goal is that should be an overarching goal is to fix actual problems. And from my perspective, I think the actual problem that has been revealed through the disclosures, and I think that there are some members in Congress who share this view as well, is one of public confidence. There clearly is has been an effect on public confidence that the intelligence community and NSA in particular is abiding by lawful process and doing its business appropriately. And so I think we need to take a careful look at which proposals will address that concern. And that's where I see some of the proposals with respect to more transparency, public communication with respect to the activities the community is doing, better explanation of perhaps some of the FISA court opinions. But I think the transparency piece is important. I think there are significant questions whether on the flip side, for example, proposals to require advance court approval for the individual queries that are put into the telephone to obtain telephone records is really a fix that is going to fix a problem versus significant additional bureaucratic and legal hurdles that will delay intelligence operations without sort of really adding a substantive value add.
You know, your last comments remind me of a conversation that was taking place between the sessions where Tim and I were talking, and some others here, about how from the point of view of those who work in the intelligence community, they've got their mission, they want to be able to accomplish it as efficiently and as effectively as possible. And there's obviously a trade-off. On one hand, the more you maximize the ease of operations for them, the more you create conditions where the public may begin to worry about abuse, worry about infringements or mistakes or malfeasance, what have you. And so you're constantly trading off constraints that build public confidence and help reinforce the idea that this is a rule-bound activity and it's democratically accountable against operational efficiency and effectiveness. And I think it's foolish for us to aim for a situation that would either be perfectly efficient from the operator's viewpoint or perfectly trusted by everyone. You're never going to get to either of those extremes. What you're really trying to get to is the best possible combination that maximizes effectiveness with trustworthy constraint, if you will. And we went through all this before. We went through this as the opening address by Admiral Inman emphasized. We had this breakdown of trust, this series of revelations and widespread sense that we need to reformulate things in the 1970s. We did eventually get back to something of an equilibrium. We had an equilibrium that was reached by the late 70s. Never satisfied everybody. There were plenty of people who were on the operational side who felt too constrained, and plenty of people on the side of monitoring for accountability who felt like it wasn't constrained enough. You're never going to satisfy everyone. But it was relatively stable for a while. We're now at a new point that's just like that, where the same sense of things having come unstuck has arisen, and we're, I think, groping ultimately towards trying to find that new balance. What's a little different here is that it's against the backdrop of a closely related but distinct disequilibrium associated with what we think about reasonable expectations of privacy in the digital age. And I think the discussion on the Fourth Amendment yesterday on the panel with Ben and Hani and Ahmed nicely emphasized this for us. There's ways that the information environment has evolved that simply require a lot of first-order rethinking, and it may or may not lead to dramatic change in the legal and policy architecture. But that's what makes this environment, I think, a much more complex process of restoring a relatively functional balance than what we had before.
I actually wanted to reject this seemingly very popular notion that like the primary goal of reform is basically to assuage the lamentably paranoid American people so they can be confident in the intelligence agencies again.
Did someone say that?
Well, I mean, I think you often get this sense that certainly from the president, and I think just to some extent it was subterranean in his remarks that the real problem here is restoring public trust as opposed to narrowing authorities that are so potent that they do invite potential abuse. I mean, I think the inability to detect at this point willful abuse is sort of the wrong test, right? For a couple of reasons. One is you don't want to wait for the smoking gun that's a mushroom cloud. The sort of scale of these disorders is so large that what you want to do is limit the ability after some future event for a system that's in place to be used in a way that violates civil liberties of very large numbers of people very quickly. And second, I think you just sort of have to assume, given history here, that you're not going to detect minimally savvy abuses, both because of the incredible scale of the activity, because from what we know historically, when people know they're doing something illegal, they do take measures to obscure what they're doing, and because again, the recent sort of history shows that even when people seem to be acting in good faith, these are pretty systematic violations of the rules can go undetected for 3 years until they're ultimately self-reported. So I think the assumption has to be you need a system that minimizes the capability to, for abuse, because you can't assume, with all respect to the diligent efforts of our friends in compliance, that you will detect an actual malicious actor's non-witless abuses.
I take your point about trust really is a term that gets bandied about at too high a level of abstraction here. And at least as I'm using it, and as I think a lot of people, including the president, are when they talk about public trust, it's not, let's just get the public back on board so we can get on about our business, calm the public down, assuage them, right, the way a parent might a child. I think that the right way to think about it is using the word trust and the public's trust as a shorthand for establishing an agreed, informed consensus on the degree of democratic accountability through transparency and a comfort level with what the operations are. And here it makes me think about Jeff Stone, who was the academic Jeff Stone was on the president's surveillance review group, and he recently wrote an op-ed that was much read, where he said, I came into the review group process very prepared to be very skeptical of the NSA folks. And paraphrasing a bit, he says, I was very impressed with these people and so forth. It was much better than I thought it would be in terms of just the sort of things the last panel and then John and others were talking about. But he also concludes at the end with a very strong statement to the effect that, like, part of living in a free society is you nonetheless don't trust, with a capital T, these institutions. You can't ever entirely trust them. It's not that we don't trust John or Raj or Chris. I think everyone who's been here the past day or so can understand how very trustworthy these people are. But institutionally, part of living in a free society is not trusting with a capital T. And so maybe it's like Reagan, it's trust but verify. So back to, from a higher level of generality, let's dive down into details. We could start with many different places, the different review group recommendations. Since the president has in fact weighed in, the most formal thing he's done is PPD 28, this Presidential Policy Directive 28 from January, where he touched on a number of the issues we've been touching on. I'd love to hear from both of you what if anything, struck you as very useful in that set of decisions, and what struck you as actually potentially problematic or simply needing more attention. Carrie, do you have
Sure.
a rogues list and a favorites list from that presidential document?
Sure. Okay, so on January 17th, again, so the president gave a very big public speech that took place at the Department of Justice, and at the same time released this presidential policy directive, which was a new directive governing the conduct of signals intelligence activities. And I think, many of us sort of on all sides of these issues, really were, waiting to hear what he would say, because I think he could have gone in different directions. Really, the president, given much of the concern regarding the activities that have been revealed, could have made very, very dramatic changes. So he could have said, as of today, we are going to end the telephone metadata program. He could have said that we're going to sort of immediately look at whether or not we should stop doing collection in bulk, which is sort of, one of the issues that has arisen of significant concern. He could have addressed desires to curtail the 702, the FISA Amendments Act collection. And he could have endorsed the Office of Institutional Special Advocate. So there really could have been some dramatic, immediate changes that he could have taken. However, he took a different tack. And so what he said was instead, when I came into office, I had a healthy skepticism for the intelligence community operations. I took a look at these programs. I directed my team to look at these programs. We made some changes, but we're comfortable with where we are now. We think that what we're doing is lawful and it's right. That being said, there are some changes that we think we will make. And so the reforms that he adopted in January covered a range of issues. One is that the directive clarified sort of existing policy and practice. It adopted the surveillance review group's recommendations to adopt a risk management approach. So I think in that policy directive, you see a lot of the risk management themes that came from the review group. It announced sort of more transparency efforts, including endorsing the idea of this outside amicus or an outside panel of special advocates who could be appointed to assist the court in its deliberations. He tasked the AG and the DNI with adding restrictions on the use of incidentally acquired 702 data with respect to an American communicant in criminal cases. He directed some changes that may take place with respect to national security letters. We already talked about yesterday some of the very specific changes that he made to the 215 program. A significant change that was announced potentially significant, I think is probably the better way to categorize it. But the new presidential policy directive includes limits on the retention and use of foreigners' personal information. And so I think this is one area in the policy directive that frankly is a little unclear at this point, at least from an outside observer's perspective, in terms of how, what the effect of that provision will be on actual operations and analysis. So basically, what the directive put forth is that in the past, the intelligence community has adopted special procedures for the handling of U.S. persons information, so Americans, resident aliens, U.S. corporations. And what he has now directed is that many of those same procedures or some type of procedures that will be developed in line with the way that the community currently treats Americans' information will be applied to foreigners' information. Now, in this case, we really don't know how that is going to play out in terms of the actual procedures that will be written. It could be that the community will adopt procedures that are identical to the way that U.S. person information is handled, which really would be quite a dramatic change in the way that signals intelligence information is currently analyzed and processed. Or it could be that they have something else in mind that will be sort of less dramatic, but I don't think that we know at this point. But that's sort of one area that I think is a potential significant change that could have very significant effects on the way that the community sort of efficiently processes foreign intelligence information, can share it with foreign partners, and things like that. And I have not yet seen the information that is convincing that is solving a problem that has been identified.
Julian, how do you feel about what you're seeing in that document?
Right. I mean, I think I agree for the most part with what Carrie said there. I think the practical import of this will depend on how the sort of general mandates are actually translated into specific guidelines. I think it's worth noting that the enhanced protections for foreigners, I think really fall out of, to some extent, something Chris Inglis talked about a couple times, which is this idea that we're sort of all on one network now, and so there isn't this kind of segregation between, ordinary civilian communications channels and, while the kind of closed government network that you need to monitor for intelligence purposes, that the rules were previously, I think, sort of crafted on the sort of premise that for the most part, just as a practical matter, when you're collecting on foreigners, they're going to be, primarily, either bad actors or, members of foreign governments at least, and there's no reason you would end up collecting large volumes of certain ordinary people's information, and so enhanced protections wouldn't really make sense, because why would you be collecting that stuff? There's always been some amount of bulk collection, but I think it's much more the case now that in the process of acquiring intelligence about members of terrorist groups or foreign governments, you in the process are doing an intake that sweeps much more broadly, and also secondarily, because what you're looking for is often stuff that's transiting on civilian networks. To enhance general intelligence capabilities, you end up collecting on people who are not, again, necessarily in themselves bad actors or linked to foreign powers. So I think of a story that ran on Glenn Greenwald's site about a kind of email thread within NSA discussing basically how to hunt sysadmins. The idea is that these are people with the keys to the kingdom, and so you essentially want to collect on people in the IT departments for large networks because you need their passwords and the ability to compromise their systems in the future in case a target you need to directly, you sort of want to primarily collect on is using a network that you otherwise have no access to. And so I think in part these enhanced protections are a recognition to a response to the fact that there's a lot of collection now happening that isn't on Anwar al-Awlaki, it's on the guy in the IT department, not because you care about him, but because you care about what it does for your capabilities to know what his communications contain.
So I want to pick up on one thing that Julian said, which he mentioned very briefly, bulk collection. And so there's another aspect of the PPD that I think is worth highlighting from the perspective of, one, what goal is it intended to achieve, and two, how will it actually be implemented, and perhaps three, if implemented in certain ways, will it be have sort of a significant effect on the intelligence community's ability to provide warning of significant events going on in the world that are of intelligence value. And that particular provision pertains to a limit that PPD 28 puts on the use of certain type of bulk collection. And what the PPD says is that certain information will only be collected, and I'm paraphrasing, but certain information will be collected in bulk only if it meets 6 specific criteria. And just to paraphrase these, the 6 criteria are espionage, counterterrorism, information about weapons of mass destruction, information relating to cyber threats, force protection, and information relating to transnational crime or perhaps sanctions enforcement. And those are sort of 6 very discrete categories. Now you might say, okay, well those sound pretty important and pretty logical, and maybe that's all that the community should be collecting about. And again, this just pertains to bulk collection. But on the other hand, those 6 categories perhaps don't include information regarding foreign affairs more broadly, information regarding sort of areas of instability, for example, the run-up to Arab Spring, events in Syria, perhaps the recent events in Crimea. So there is foreign intelligence information that would fall outside of those 6 criteria. So the question is how, what exactly will the effect of this type of limiting provision be? Part of the question to that answer, I certainly don't have the answer to, because it would fall on what percentage of NSA's overall SIGINT collection is this type of bulk collection that this provision is meant to address. If it's a small percentage, then perhaps this is fairly inconsequential. If it's a large percentage, then perhaps this substantive limitation on what the NSA, the purposes for which it can collect information, could be significant in terms of the conduct collecting intelligence information in order to protect the national security.
I mean, you have to flip this slightly, right? Is that one of the kind of classic categories of foreign intelligence information, alongside information that protects the national security of the United States or protect against clandestine intelligence activities, is information that relates to the conduct of the foreign affairs of the United States, including information that relates to the intentions of a foreign power or other foreign entity, which is, I think, obviously so kind of incredibly broad that that under that category of foreign intelligence information, there's not a huge amount of stuff you can't plausibly collect, with some rationale that in aggregate, that this is information that would enhance our ability to understand what the government of a foreign country is likely to do, or a foreign, some other foreign political entity. So, whether or not you think additional categories should be added to these, in some sense, if you don't cabinet a little bit more narrowly than the sort of traditional definition of foreign intelligence, given the sort of enormous collection capabilities, you end up without very serious restrictions on collection on, again, ordinary people, because it might shed light on something a foreign entity is going to do.
One thing I seem to recall being in the statement, there was some reference in the PPD, I thought, about information sharing with private industry, if I recall correctly. And this is something that one of the themes that comes out in articles about NSA doing this or that. You often see, especially in foreign sources, concern that one of the things NSA might do is gather information on company X abroad, information that would be useful to an American private business in competition with that entity, and passing it along, or somehow sharing it in a way that favors U.S. industry. Now, I'm actually myself not aware of any stories over the past 9 months of disclosures that actually vindicate that concern, but it comes up a bunch nonetheless, and I have the general impression that people abroad generally don't believe U.S. denials, that when we deny that we share information to aid our private industry that way. Do either of you recall if either the president or any of these other documents have talked about making more clear that we do not do this, perhaps even making it explicitly clear that it should not and cannot be done, more clear than it is?
Yeah, I mean, it's in there. There is a trade secrets and other information about private economic activity shall not be shared except for sort of certain limited protective purposes, but that there's an explicit prohibition on. I mean, I think this has been sort of the long-standing policy, but
do you think this actually is something that's just an impression problem, a PR problem, or do you think it actually maybe really is something we're sort of doing on the margins that we need to police
I
against?
have no idea. I don't know I don't know how you would know that.
Susan, you want to weigh on that? Oh wait, here comes the microphone.
The Economic Espionage Act makes that kind of sharing, not from the government to private industry, but economic espionage a crime. And that the U.S. is, if not unique, fairly close to unique in making economic espionage a crime. Whereas other governments, whether it's France, Japan, multiple other governments, but I know France and Japan for sure, explicitly have that as part of government function to do that kind of spying and share it with. So I think there is a perception problem, but it's a perception that we can't fix, except, the statement by the president that Julian just mentioned, and said, look, that's an explicit statement, but a policy we've had forever is exactly right. We've had that policy forever, and you can find it stated in various places obliquely, including in National Research Council studies. I think it was useful that the president said so, but there's nothing more that we can do. If other nations do that as policy, they have trouble believing we will.
So it's both a perception problem that puts us in a light that's really not fair, and also there's an uneven playing field problem that others actually affirmatively do this. Alex wanted to weigh in, and perhaps Tim as well.
I just wanted to point out section 1C of the PPD.
1C, okay, good. Tim?
I guess my thought here is that it's easy when we're talking about reform proposals to jump to the rules of what should the rules be for all these different activities and what should the restrictions be. And Carrie's kind of laid out her theory that you should be solving actual problems. Julian's saying, no, these are broader issues that we have to address even if they haven't resulted in something like a willful violation. I guess my question is, it seems to me that one of the big issues is institutions and strengthening those institutions before we even get to the rules. And let me give you an example. I was pleased to see a lot of people thought the idea of a chief technologist at the FISA court would be a good idea. Here's another thought. We sometimes hear proposals to change the rule to make the FISA court make more granular decisions. And we've already seen that happen with the telephone metadata program. I believe that the seed numbers now have to be approved individually by the court. The pushback for that proposal is always, this is going to slow things down. This is going to be a nightmare. There's going to be 5 lawyers at the Justice Department and another 100 lawyers at the NSA, all passing paper back and forth and then going to one of just a few federal judges appointed to the FISA court making these individualized decisions. And it strikes me, and I just sort of checked this again during the conversation, both the pen trap part of FISA and the business records part of FISA refer to magistrate judges, which I don't believe have ever been used. But it's sort of like, why the heck not? I mean, why can't you streamline this process? Beef up the FISA court, have more staffing at the FISA court, employ things like magistrate judges, make sure that your streamlined process, an analyst sitting at their computer who has to make a decision that currently is just a decision that's internally reviewed by John's office or maybe after the fact or consult with general counsel. Why couldn't you set up a computer system so that decision very quickly gets passed through a review process at justice, or maybe even doesn't, goes straight to a judicial officer, such as a magistrate judge, for approval or denial? That's not changing the substance of the rule, but it's changing where that rule is being administered. It's changing it from an executive branch official to a judicial branch official without any loss of speed necessarily. But it requires significant institutional change. I mean, institutional change internally, the executive branch, institutional change at the court, and it's constantly, that question has always, to me, been sort of very frustrating, because those on the outside seem to think, oh, that's really simple. Why don't they just do that? Those on the inside are sort of like tearing their hair out and saying, oh my gosh, that would be impossible. That would never happen. Have we got the cart before the horse here? Because it seems to me that instead of debating these rules, we should be debating first how to make the institutions that are going to work to apply those rules in a way that provides for maybe additional oversight that we then want to change the rules to allow.
Carrie?
Sure. So Tim, you're absolutely right that those provisions do include this option for going to a magistrate judge. As far as I know, that never has been implemented. And so what we have as a practical matter is all matters that are presented to a court under FISA go to the judges who are designated on the Foreign Intelligence Surveillance Court. Now, I can speculate as to why it is that the magistrate option has never been used. And I think that there are issues with respect to geography, technology, expertise, and sort of government business process that all fall into why along the line nobody has said, hey, this sounds like a really great idea, why don't we do it? So geography, if you start using magistrate judges who are all over the country, you have to sort of build in all the security. One of the reasons the FISA court was created to begin with was so that you could develop a set of judges who develop expertise in intelligence law and national security matters, so that you could, the government could control as a matter of physical security the information that is presented to them and the data, the documents and things like that, all in a secure environment. If you start spreading that out nationally, that becomes an issue. Regular courthouses in Austin don't necessarily have secure phones, secure computers, secure storage space, and sort of all of those mechanics that go into trying to implement something like that. However, I would also suggest that with respect to various proposals to add additional FISA court process, for example, this idea of adding, what's now I understand to be the case today, and which is in some of the proposals going forward. I think the administration's proposal going forward on 215 is to have this advanced court approval for the RAS queries. So my argument is not solely one of sort of speed and efficiency. It's also one of value. So part of the argument is that when we are focusing the attention of the government lawyers, analysts, and judges and executive branch management personnel, lawyers, and the judges themselves, when we are focusing so much of their attention on what is constitutionally not protected information, right, which is records, as was discussed yesterday in the discussion on 215, digits dialed. I actually think that we run the risk of focusing their attention on the matters that do not as much significantly impact civil liberties and privacy versus allowing them more space, time, effort, attention to those cases or matters that might be presented to them that do substantially impact civil liberties and privacy. For example, applications that target U.S. persons, applications that might be sort of complex and novel and impact civil liberties in some other way. So I think in terms of evaluating these proposals, again, that sort of comes to, what are the actual goals? If our goals are to make sure that the FISA Court is giving its best attention to matters that substantially impact civil liberties and privacy, then why are we coming up with proposals that are going to increase the time they spend on records check, which if you were in the criminal side could be attained by a subpoena tapped out by an AUSA and doesn't even go to a judge, versus content-based collection that substantially impacts privacy?
Julian?
Sure. So, there may be logistical reasons that for not going the magistrate judge route, but the size of the FISC has been increased in the past. It could presumably be increased again. There's not an infinite supply of security cleared judges with the proper expertise, but I don't know if it would be completely implausible to double the size of the FISC if necessary. And I'm also not sure how serious the burden is if, as Stephen Bradbury keeps reminding us, there are only a few hundred queries, let's say, against this database annually. I assume that's not literally here's this number, here's the next number, but probably much more often here are 5 cell phone we found at a training camp in Kandahar, and so here's the list of 50 numbers that we pulled from those address books. I don't know in practice. Literally I don't know, because I don't know what the scenario is for actually acquiring the particular numbers they're feeding as seeds, but a combination of expanding the capabilities on the authorization side to meet the additional burden, and finding ways to streamline the process so that in practice the burden is not that great. I think you can those two things can sort of meet in the middle and render this tractable. More generally, I just want to sort of step back and say that is actually your broader concern that with too much narrow focus on the rules is one I share. I have almost the inverse frustration from Chris Inglis. He was sort of annoyed that we talk so much about capabilities and not about the specific authorities. I think we do spend a lot of maybe too much time debating the specific rule that's going to be used to access data under a specific program, and not enough time sort of talking about broader architectures. So, when you think about something like Turbine, which is sort of the delivery system for exploits that appears to be sort of integrated with the backbone, we can have a conversation about, all right, if you've got this sort of scalable exploit delivery mechanism, what should the legal standard and the evidentiary standard be to use a particular selector and target those machines for exploitation? But kind of before that, I think you want to ask, do we think it's a good architectural decision to plant an exploit delivery device on the internet backbone? Is that a design decision that is sort of robust over time?
Before I encourage the audience to ask a few more questions, I want to give each of you a chance to identify, if there is something like this for you, 2 or 3 things that at the end of the day you really hope are in fact done to change the status quo, or conversely, something you really hope does not happen as a result of this process. And it may be that you don't have such a list, but if there are a couple of things that, bearing in mind the audience is not just everyone here, but it seems like we've got a lot of people watching online, so express your views. This is your chance.
So I think transparency is important, and this is fortunately something that seems to be pretty broad consensus about, that we can be more transparent than we are being. We hear a lot about the robust oversight from all these Article 3 judges on the FISC and the committees in Congress, without really recognizing the extent to which those oversight mechanisms normally function because they're embedded in a broader public system where judges have reputational concerns. You know, am I going to be smacked down by the appellate court? Is the Harvard Law Review going to make fun of my, my outcome-driven ruling? The extent to which legislators, right, rely on the sort of lobbying as legislative subsidy, rely on outside expertise to sort of increase their bandwidth in a way that you is not available if you're just counting on a very tiny number of cleared staff without that ability to draw in outside expertise. So transparency, I think, is something that will make all the other oversight mechanisms work better. Something like restoring the the idea of a nexus to a particular suspect, again, across authorities, national security letters, 215, pen registers. This language that's in the USA Freedom Act that the Senate unanimously approved in 2005 and was swapped out in conference at the last minute, just establishing that when you're getting data, there needs to be some factual basis connecting it in a particularized way to some person or entity that you have actual suspicion about. And then third, I guess, more generally, across authorities, but certainly in particular 702, kind of ending this shell game. I think we see certainly you see this in the sort of the logic of the 215 order, where you have much broader upfront collection justified by restrictions on the back end that are somewhat optional, and then kind of after the acquisition occurs, the sense that, well, why do we have these back end restrictions? We've lawfully required this information, so why would you make us jump through all these hoops to use information we already have? And, again, I think we see this pattern over time where this collection up front premised on back-end restrictions serving the function that a narrower aperture on the front end would have served in the past. And then over time, we've got it anyway, let's loosen the back-end restrictions. I think we want a sort of more holistic approach here that locks in both things at the same time. So, again, if, for example, you are permitting, let's say under 702, broader sort of front-end collection of American data on the premise that you're not targeting them, that you don't then on the back end say, well, now that we've collected it, we can target them at the query side.
Carrie?
Okay, so I'll do one objective that I hope is achieved and one proposal that I hope does not see the light of day. So on the what I hope is achieved is, I think one of the as sort of a principle that I hope will be sort of a guiding principle in terms of the reform proposals that are before Congress is I do think it is very important that whatever legislation is put forth or potentially passed is very clear and understandable. I think the SSCI and Senate Judiciary, the Senate Intelligence and Senate Judiciary Committee bills are pretty good on this front. I think the recent House Intelligence bill perhaps could be clarified a little more. I think even for sophisticated readers of that text, particularly with respect to when the timing of the directive that would be issued by the court on the queries and whether or not those directives are programmatic or individual per each query could be made more clear. And, this is part of the process of legislation, and I expect that, as that bill gets debated amongst committee members and things like that, these types of changes will be made. But I think as an overarching goal, it's very important that whatever comes out of this process, if it is legislation, is very clear and very transparent, and everybody is on the same page as to what that text authorizes.
The HPSI bill is like the legislative equivalent of a Rube Goldberg machine. I did a kind of longish post at Just Security looking about this. It's just structurally super weird in a whole bunch of ways, and there's a ton of ambiguities and frankly, constitutional questions about whether the effect of the new authority there is good. This is something I certainly would not want to happen. You can read the new authority the HPSI bill creates as mandating the creation of new records and potentially the collection or retention of new data. So not just you need to kind of reformat something and store stuff we need in a format that makes it easy to aggregate and cross-reference it. That seems fine, but could be read to basically say you must now store and retain and collect data, in record form that you would not otherwise do, which, if nothing else, I think is sort of constitutionally dubious. Right? If the logic of Smith v. Maryland is you lose your privacy expectation because this is information you're sort of voluntarily submitting and that is being retained by the company, and then you say, well, but they're only retaining it explicitly under a mandate to aid government investigations. That seems like a kind of a two-step that should be constitutionally suspect.
Julian, on that last point, so we're talking about telephone metadata. Is that actually, do you think, possibly purposeful on the theory that though phone companies have for their own business records, kept toll dialing records, but frankly, we don't really live in that world anymore. As we move to a bandwidth-based service, they wouldn't otherwise keep those.
I think it probably is. I mean, and it's because, of course, it's not just telephone metadata, it's electronic communications records generally. It's very easy to imagine some online communication service that has no reason to collect information about who you're communicating with or other features of the communication, in the same way that Comcast normally has no reason to process or store any of the details of who I'm opening an IM session with or who I'm emailing, right? I mean, all Comcast needs to look at is where the packets are going. They don't need to know anything below that level in the OSI stack. And so I think one consequence of this is potentially to create a system where that information is retained in a place where the government has access and visibility.
I think this is really important. I mean, recall that the Internet Metadata Collection Program, eventually, long before it was all revealed to the public, the government simply stopped seeking renewal because companies just didn't keep the records in a way that facilitated this. And were we to move to a model that by statute began to require companies to maintain records?
So the Internet Metadata Program, as I understood, was under the Pen Trap Authority and on the backbone. So it wasn't actually about acquisition of records. It was about collection of metadata as it flowed through the pipes.
Right. So Chris the other night said that one of the core problems was it just didn't work very well. The information wasn't presented in a way that we were able to collect it. You could avoid that problem if companies began to have an obligation to keep that data, even though they otherwise wouldn't.
Right. But again, I think that if you look at the sort of the reasoning of Smith v. Maryland, it becomes substantially more constitutionally dubious if the premise here is you're waiving your expectation of privacy because information is kept in records that the government has mandated, not for some independent purpose, which is often the case,
think that's
but
exactly right,
specifically
Dr.
to aid investigations.
So just to follow up on 2 points, so a final thought on the HPSI proposal. It is possible. The HPSI proposal, to its what is commendable about it is that it was introduced in a bipartisan way, and so it's possible that there were a lot of constituencies that needed to sort of be satisfied for that bill to be able to be presented with the support of both parties, which in the current environment is a laudable achievement. You had asked Bobby earlier if there was a second thing, sort of a proposal out there that I hope does not go forward. And on that point, I would mention the proposals to add the institutional office of special advocate to the FISA court. So again, as we mentioned at the beginning, there are sort of two competing proposals in broad categories. One, to add this institutional offices that would sort of be like a public defender's office for the FISA court. And this proposal, as I've written and said elsewhere, would add significant bureaucracy that would not necessarily be tailored to the cases that most need it. So some of the proposals would have this Office of Special Advocate, have the ability to insert itself into any case, to appeal and things like that. And that really could dramatically sort of change the effectiveness of the FISA court. The counter proposals that are on the table are to enable the court to appoint some sort of advocate, amicus, whether that would be if there was a legal issue that the court wanted additional views on, or even a technological matter that it wanted additional views on. It could do that. And Judge Bates, the former presiding judge of the FISA court, actually, in his capacity, wrote a letter to Congress saying that this the first proposal, the institutional Office of Special Advocate, from the judge's perspective, actually would potentially be both unnecessary and potentially counterproductive. So that's one that I hope is abandoned in light of other
But I
options.
mean, as a practical matter, we think the special advocate is going to be inserting itself into 1,500 applications for a, targeted electronic surveillance order on a particular person. It seems like that. I mean, right? No one thinks that's necessary, but I wouldn't expect them to get involved in those either. You expect them involved in very sort of large programmatic authorizations where it seems like a couple days of extra overhead, is probably worth the candle.
Sounds like you guys agree on the basic principle there, but are unsure on whether to err on the side of not establishing an institution that might get over-involved, or let's make sure it's there so that it can be involved where it needs to be involved. Let's get you guys involved. We have a little bit of time left on the clock. Are there things that you want to see in reform or hope you do not see in reform? Margot?
I'm just thinking about something you said, Carrie, in the course of this, which was that, gosh, there hasn't been evidence of willful violations of the rules. And I'm wondering why that's the question. I mean, why do we think, if there was a small but willful violation of the rule, would that be worse than a big but inadvertent violation of the rule? And why? So I guess in thinking about the path forward, I've heard a lot of people talk about the mens rea of the folks at NSA as if it matters, and I don't understand why it does. So I wondered about that.
Well, I think the reason that I raise that in terms of, there haven't been allegations, sort of realized allegations of abuse or willful violation, sort of goes to the question of what problem is it that we're trying to fix. And so if we're not trying to fix sort of identified problems or things that were done wrong, then how does a proposal to cabin the categories of intelligence information that we're collecting about, how does that respond to the concerns that are currently being addressed? Why would advanced court approval of queries for telephone records respond to the concerns that are being expressed? So I think that's why I raise that, because I think there is a legitimate question between what are the proposals that have been that are on the table, for example, with respect to transparency, which I think the proposals on transparency really do get at the problematic issues that have been raised. The one of that the public is not able to, didn't have enough information at its hand to provide confidence. So I think the transparency proposals. I actually am somewhat concerned that the substantial focus on this one telephone metadata program will perhaps push some of these transparency proposals aside, and they will sort of fall by the wayside. And I think those actually are perhaps more responsive to some of the actual concerns that have been realized.
I touched on this earlier, but if you look sort of historically at the kind of abuses that you were sort of the paradigmatic thing we're trying to avoid, in a lot of those cases, there's nothing that sort of happened internally that you could call the willful abuse. If you reading someone's mind and saying, why did you access this for a good reason or a bad one? It's there's information collected maybe for some colorable foreign intelligence purpose, and then the abusive part is. So this was then shared with the White House, let's say, for purposes of political intelligence, and that's sort of not something that you can, right? Sort of that's going to show up inside the box, right? That has to do with what is in someone's brain and what they do with the information, after they leave the office. So, yeah, I mean, it seems to me that the sort of structural reason to ensure that lots of information isn't there to be misused. Isn't that you've spotted particular cases of it, in the recent past.
General?
Thanks. Julian, if I heard you correctly, I think that you were saying that our external collection ought to be focused on state actors because that's where the preponderance of the threat lies. But I wonder how we reconcile that with the concern that we have with non-state actors and they not be formalized within a governmental structure.
No, so what I was saying was that the change in the rules, to some extent makes sense in the context of a shift in the kind of collection we're doing where, it would make less sense to have more stringent protections for foreign and person information in the context of, let's say, Cold War type surveillance where the majority of the people you're collecting on are, people who work for the Russian government, let's say. And that when it starts to be the case that you're collecting on, larger numbers of ordinary people to figure out who is a malicious non-state actor, or you're collecting on people who work in telecommunications infrastructures to enhance their intelligence capabilities, so civilian telecommunications infrastructures, that as the sort of aperture of collection broadens, the kind of back-end, the urgency of back-end restrictions on that data becomes greater. Does that make sense? Right, so I'm saying it's because we're collecting on lots of non-state actors now, in a way that was probably less the case in the past.
Tim?
I guess I'd like to propose maybe a compromise on this issue of how bad does the violation have to be before we care about it, and say that maybe those who are worried about privacy and civil liberties have a point here, that violations don't have to be willful and abusive, and there could be real concern about even potential violations or unintentional systemic violations. But that sort of on the flip side, the standard of whether there's value in the program can't be whether it was the but-for cause of preventing a terrorist attack. It seems to me those are both artificial standards in a way, and that if Julian would agree that a program can be useful even if it wasn't the but-for cause of presenting a terrorist attack, would Carrie take that in exchange for agreeing that maybe potential violations are also something to be worried about, and we don't have to solve only the problems that have actually happened already?
So, well, I think the sure. Well, I don't. So one, I think that to the extent that is a standard that's imposed, I think is because right after the disclosure of the 215 program, the government rolled out sort of this claim about 54 disrupted terror events, which people took to mean plots, ended up including a lot of material support cases. But to the extent that's a standard, that's I think because that's an own goal, right? I mean, it's a standard that they decided to use to demonstrate the utility of the program. I think the PCLOB report is, again, reasonably, sort of sophisticated about this, recognizes that, being the but-for is only one kind of utility you can provide to an investigation. And so, right, so obviously there are a lot of other ways information can be useful. I would sort of, dig in my cleats a little bit on one point, which is what you do want to be thinking about is sort of the marginal utility. So not just, would a terrorist attack have happened but for this particular piece of information? But you do want to be sort of asking not just, is information we've obtained under this authority useful, but how much marginal gain are we getting relative to a less intrusive authority? So, if you had a general warrant, you would of course get tons of useful information that would help you make a lot of criminal cases. The question is, what are you getting relative to what you could get with specific warrants? And so, to the extent there's a but-for there, it should be that kind of condition or question should be asked only to establish that the authority that you're using here is giving you a substantial gain over a narrower authority that would give you 95% of the value with 5% of the collection or intrusion.
Carrie, I'll give you the last word.
Okay, sure. So I guess the way I would respond to that is, first, I think it's worth considering that some of the proposals, for example, there are proposals on the table to add connection to agent of a foreign power, for the records checks. There are proposals to add these additional layers of FISA court of approval. There are, lots of more procedures that are going to be implemented. And so I think part of what I'm suggesting is that we should tread carefully in terms of adding much more procedures, much more process. In some cases, they're not here, I've heard, but in other events like this, I've heard it suggested that we go back to sort of agent of a foreign power standards and sort of re-raising standards to pre-9/11 standards in some contexts. And so I think we just need to have our eyes open in terms of if that's the way that the direction this conversation is going. Those additional bureaucratic procedures and processes and standards will have consequences. And so we need to be mindful of that. But certainly on sort of the compliance incidents piece, having been someone who spent many years conducting the oversight and compliance, and at the very granular level, reviewing the activities of NSA to ensure their compliance and their reporting with compliance matters, I certainly understand the value of being knowledgeable about those compliance incidents and being able to correct them, and that there's not only sort of one type of compliance incident that is important or not important. But again, what we haven't seen is any suggestion of sort of strategic level 1970s era abuses of the system. And so our proposals to reform should take that into account.
We've talked so much about institutional efficacy, and I would be remiss if I didn't point out at this point that the institution of the Strauss Center, which is partnered with the Clements Center in putting on this event, depends and runs on its personnel. And if you feel that this event has gone smoothly and it's set up in the past day and a half, that's entirely because of the extraordinary people that work with me. Ashley Moran, Andrew Earhart, Jessica Mahoney, and Dominique Thuot all deserve a round of applause for making this run so smoothly. And of course, what also ran smoothly was this panel, and thank you very much to Julian and Carrie. And we are concluded. Thank you guys so much for being here.